Hey guys, hello. I did say in my video this morning that I might be live. I had a sneaking suspicion that things were going to come out today, and some things have come out today, and it might not be the only things that come out today, so we'll see how we go. The most alarming thing though to come out is this letter. A letter to the court by an inmate at Westville Correctional Facility, of course, where Richard Allen is being housed. Oh dear. Okay, so we're going to get into that. There's also another amicus brief been filed with the court. There's been an administrative error, so I think they have to resubmit it. So I don't think the Supreme Court of Indiana have got it quite yet. It was submitted this morning, and then they basically sent it back with things that they needed to correct. But I think it's just administration and stuff. So I do have that as well. So we can take a look at that. I mean, the new revised version might change a little bit, but the gist of it won't. And of course, it is the deadline for our good old dishonourable Francis C. Gull to get her shit together for the first writ. Now, I know there's been a lot of confusion, so I'll clear that up first before we do anything else. There's been some confusion about Francis's deadline because there's two writs. This is the thing. There's two writs with two different case numbers. And I think this is where the problem has occurred, that people have got confused. So the first writ, which has the case number of, hold on, it ends in 302. I'm not going to read the whole thing. It ends in 302. That was submitted to the Indiana Supreme Court, and Francis was given the deadline of Thursday, the 9th of November, and she appealed for extra time. She appealed for an extension of 5 business days, so a week, which was granted. So the deadline is today. That's the first writ. And then a second writ was filed to the Supreme Court of Indiana by Cara Wernicke and team. And the Supreme Court accepted that and gave Francis the deadline of today. But because she'd already had an extension, she ended up with 2 writs being, her response being due on the same day. So she applied again for an extension to the second writ. Are you following me? So the first writ deadline after an extension was today. The second writ after an extension, which was also granted, her new extension for the second writ is the 27th of November. Do you remember we had this conversation on a previous live stream that she asked for Thanksgiving as a day, a holiday? So basically not counted in business days, of course. Thanksgiving is a holiday, so rightly so, that shouldn't count. And then do you remember us having that conversation about Lincoln's birthday? That Lincoln's birthday is actually in February. Do you remember this? Those of you who were in, President Lincoln, Lincoln's birthday. But it came to light that some counties in Indiana actually celebrate Lincoln's birthday in November as like a discretionary day. So instead of it falling in February, it falls in November. I don't know. Listen, we had a big discussion about it. But it turns out that they did grant that deadline. So the deadline for the second writ is the 27th of November. So the first writ, I went through it yesterday in my video. I think it was yesterday or the day before. I can't remember. All the days meld into one. So go back to that video because I read what Francis had to provide And I also read what she's already provided. So she's already done 3 out of the series of things that they want. So she's already done some of them. But she's got a deadline for all of it as of close of business today. So there we go. So there has been a lot of confusion. I've seen some confusion in my comment section. I've also seen confusion on Reddit. So I made a very rare post. I don't post much on Reddit at all. But anyway, all right. So yeah, go to yesterday's video if you want to see me discussing what she's got to do, or what at least she's got to respond to by close of play today. So we'll get into what the new things are. So there's a new amicus brief and this letter. I'm going to start with the letter because it's really, really concerning. So I'll give it a minute just for people to get in here. The unraveling's in the house. Hello, hello. God bless Indiana. Or God save Indiana, rather. Yeah, somebody needs to save them. Somebody definitely needs to save them. Hi, Tara, Plant Lady, Mom, me, Stephen, Cecile, my perpetual apologies, Pincho, Mike, Shazza, Mel, Regina, Art of Deduction. Hello, hello. I've been watching some of your videos as well. So the Unraveling and Art of Deduction both have channels. So go and check those out if you want to. Jennifer, Purple AJ, Birdhouse, Sue, Betty's Barn. I'm sorry, Betsy's Barn. I still need to get new glasses. I still can't see. Sweet Peas, Nicola, Only Grands, Honey Elder, Kai Mojo, Jackie, Journey Takes a Trip. Oh, you did take a trip. You drove for 2 hours, arrived at destination, saw the live starting. Well, isn't that just perfect timing? Hi, CW from the northwest of England. Is it raining where you are? It's raining here yet again. All right. Okay, let's make a start. So we've got a bunch of people coming in now. All right. Okay, make this a bit bigger. So it is difficult to see. I've struggled to read this a little bit, and some of the words I can't. Oh, you're welcome. You're welcome. You're welcome. If you've got a channel, if you know, you guys who regularly come into my live streams, if you've got a channel, let me know, because I'll let other people know as well. And if it's not a channel that I've heard of before, then I'll check you out. I'm always looking for new channels to look at. Okay. All right, this letter, it's worrying. So this is somebody called Robert P. Baston, inmate number 209210. And where has this letter come from? Well, this letter was hidden. This is one of the things that Francis was asked to unseal. So this has been there, sealed, for several months. So like June, July time, this came into the court. This was a letter written to the court by inmate Robert Baston. And none of us have seen it until now, because Francis, in her wisdom, sealed it. All right. So it's one of the things that the first writ asked her to unseal, and it's one of the things that she agreed to unseal. So, as I said, some of the things that were requested from the first writ have now been done. All right. No rain in Warrington. Oh, well, maybe it's coming your way next. Maybe it's coming your way next. Because Baston sends a lot of letters. Well, maybe he's got a lot of time on his hands. Maybe that's why. Okay. So, inmate at Westville Restrictive Housing. Something. I can't read this. I think it means he was subpoenaed to appear in the above cause number. So, State of Indiana, County of Carroll versus Richard M. Allen. On Thursday, June 15th, 2023, at 7:30 a.m. in the Carroll Circuit Court. Okay, there's the address. Due to corruption and retaliation by Westville's restrictive housing unit staff and officers, I had to refuse to appear in the above-mentioned court hearing due to my safety and fear for my life. Now, bear in mind, this is an inmate. This is just someone's opinion, and, you know, as an inmate, he might have grudges against staff, officers who've done nothing wrong. Let's just be clear. I do like to, you know, show both sides, and it could well be that he's got a grudge against Westville, or against Carroll County Court, or against the judge, or against anybody, right? So we're just reading it as it stands, and, you know, you make your own opinion about it. But it is concerning, very concerning, I've got to say. Okay. I had to refuse to appear in the above-mentioned court hearing due to my safety and fear for my life. I was housed in a cell A2-206, just above Richard M. Allen's cell, A1-107, due to being a voice, I think that says voice, on how Richard M. Allen was being abused and mistreated by corrupt sergeants and officers and administrative staff, and something mental health professionals in Westville's restrictive housing unit. I was retaliated against and moved by orders of Warden John Gallipo, Captain Gary Lewis, and Restrictive Housing Unit Manager Mrs. Tracy Cornett. So again, this is just what one inmate is saying. Okay, gotta take it for what it is. So apparently he was a voice for Richard Allen because Richard Allen was being abused, and because of being a voice, he was moved. All right. Okay, next page. I was moved to Restricting Housing Unit B-Pod, Cell 201, after reporting Sergeant Brandon Williams and his officers trafficking contraband to inmates in A-Pod to the Indiana Department of Corrections Office of Investigation and Intelligence, something Internal Affairs. I'm reading this for the second time, and I'm reading it better. Reading it better now. I always have a problem when people write in all caps. I like, my brain can't function with all caps. That's true. Richard Allen doesn't look half dead because he's being treated with kindness and love. No. Okay. I don't expect kindness and love. I just want half decency will do. Honestly. That'll do. Okay. All right. If somebody was treating an animal like this, I'd be on an absolute rampage, and I'd be, I don't know, I'd be getting on a train or a plane or something to go and beat them, beat them senseless. But when it's in a prison, you've got a problem. Allegedly, when it's allegedly in a prison, you've got a problem. All right. Okay, where were we? In a recorded interview on April 28th, 2023. 5 days after the interview, on Wednesday, May 3rd, 2023, at approximately 7 a.m., Sergeant Brandon Williams and his officers, while I was in full restraints and leg shackles. Oh, they do like their leg shackles, don't they? In Westville's restrictive housing unit, receiving area on security cameras. Punctuation would help. On security cameras will show Sergeant Brandon Williams ordering an officer to put my mattress in urine in a cell that I was placed in the night before, without a toilet and running water in the cell. This is grim. Security cameras will show Sergeant Brandon Williams slamming to the floor and violently, what's that say? Something my foot, breaking my foot, violently breaking my foot and ankle, and then intimidating the nurse, I think, not to treat my injuries when Sergeant Brandon Williams and had an ink pen in the stab vest that he was wearing, stabbed me in the elbow all the way to the bone. Dear me. Okay. I mean, listen, if this is on security cameras, are these people fired? Are they waiting in the line at the, for a new job? The job centre. Don't know what you guys call them in America. You call them job centres. Do you think he's a liar, Stormy? He might be. Might be all lies. But he's saying that the security cameras. So at least it can be investigated, can't it? If it's on security cameras. Okay. I was then placed in a cell 201 in B pod. Then at 10:45 a.m. on same date, Sergeant Brandon Williams gave no verbal command to cuff up at my cell 201 B pod. And dropped the handcuff port in the cell door and sprayed OC pepper spray in the cell, and then left me in the cell for 10 minutes, asphyxiating for air. I then was handcuffed and removed from cell out of view of security cameras and taken out in the hallway where an officer, Quinton Davis, was waiting and told Sergeant Brandon Williams and officers to hold me up while Officer Quinton Davis violently punched me in the ribs and stomach while an officer, Mr. Motts, or Matt, maybe, kneed me in the face. Good God. While Warden John Gallipo, mental health doctor Monica Wayne, and Miss Bourne were watching the beatdown from outside Captain Gary Lewis's office. All very Shawshank Redemption. Okay. All right. The nurse, again, was intimidated not to treat my injuries, and I was placed back in cell 201B pod. I was placed on strip cell, and my personal property was taken when I... does that say? I eventually received my property back. My legal documents were either destroyed or lost or taken due to incriminating recorded dates and times. Some of these recorded dates and times concern how Richard M. Allen was being abused and mistreated by staff and officers. Okay, and it continues. My personal property was left out in the hallway, unsecured, and Westville Restrictive Housing Unit general population workers and suicide companions, I think that says, were stealing my property. I recently received from the United States Department of Justice investigative report number, and then there's the number. Okay, but recently the US Department of Justice has been in the news for mishandling complaints. Okay. The Indiana Governor's Office of Ombudsman Bureau has also mishandled complaints on the Indiana Department of Corrections and the corruption going on in DOC facilities. The Indiana Department of Correction Office of Investigation and Intelligence, Internal Affairs, is allowed to police itself and covers up excessive use of force, assaults on inmates by Department of Corrections staff and officers. It seems to me, right, that this whole place just needs a new governor, it needs new officers, and it needs new staff. Just sack them all, just fire them all, and get new ones, and then let's see how that works out. Just dear God. Okay, right. I've also been corresponding with a New York Times investigative reporter and her team, I think that says, at the Yale Law School that I have been sending documentation and evidence to. But due to the corruption, my legal mail has not made it to its destination. Okay. So he then writes this letter and it gets sealed and it sits there sealed for 6 months or 5 months or however many months it's been. I think this is from July. Oh, it should be, Mel. Yeah. It should be. These are very, very serious allegations. And it's if you're saying that at least some of it can be seen on security cameras, if the security cameras haven't mysteriously been deleted or mysteriously weren't working that day, which is what is usually said when things are on or could have been on security camera. Oh dear, that camera. Oh dear, rats got into the wires and oh dear, it's not working now. That kind of thing. But yeah, at the very least, this should be all investigated. Okay. So until this court can protect me and other inmates at Westville Restrictive Housing Unit and report the excessive use of force, assaults, abuse, mistreatment, torture, and retaliation from corrupt Indiana Department of Corrections staff and officers, then I do not feel safe to testify in Allen's cause when a pattern can be shown of the above mentioned issues by researching the named individuals mentioned in this court letter. in the United States District Court, excuse me, Northern District of Indiana, 7th Circuit. That clearly shows a pattern of excessive use of force, assaults, torture, abuse, mistreatment, and very poor mental health treatment. Again, I have witnessed Richard M. Allen being abused and mistreated by Westville Correction Facility, Westville Restrictive Housing Unit staff and officers that has affected his health and mental health. I, Robert P. Baston, 209-210, ask this court to report this corruption to the proper authorities to investigate. Okay. And that's it. So, how do we feel about that? I think the very least, was it investigated? Was any of this investigated? You know, even though we've not seen it, the court staff saw it. Francis C. Gull saw it. Remind me again why Richard Allen has been denied removal from Westville. Remind me again why he's there. Remind me again why he's there. Is it so that he can be kept safe? I seem to remember that he wouldn't be safe in a county jail. So the only way to keep him safe is to send him to a prison, even though he's innocent, till proven guilty in a court of law. And he's got no hope of a trial anytime soon. So remind me again why the repeated requests by his original and rightful attorneys, Andrew Baldwin and Brad Rosey, their appeals to have Richard moved to Cass County, who Brad Rosey personally arranged with the warden there for Rick to be housed there at Cass County. Sheriff there said, yeah, we'll have him. We don't want him, but we'll have him and we'll keep him safe. We'll do the job. We've got the facilities. We can do the job. So despite Francis C. Gull having this letter, and surely she must have some power to at the very least investigate this, or at least move it along to the correct people who would investigate. You know, given that somebody, you know, a defendant of her court, Richard Allen, is there for his own safety. Given this kind of allegation, wouldn't it be safer to move him to Cass County, where his attorney personally arranged for him to be housed? But yeah, this is one of the documents that wasn't released when the 118 documents were released at the end of June. This is one that was sealed for whatever reason. I can't imagine why she'd want to seal that. I can't imagine why she'd want people not to know that her narrative of is in Westville to keep him safe. Well, she wouldn't want this coming out, would she? Because it kind of goes against that narrative. And now he's got to wait until next October, at the very least, for a trial, when his trial was actually due to start on January the 8th. Jury selection due to start January the 8th. And then we've got all of this complete nonsense. And I think we can be very, very safe, very safely assume that this leak that supposedly was so tragic and so damaging is just a bullshit story, because there'd been leaks coming out in 2022, if not before that. We know that Court TV has had 2 people on, an author and a podcaster, both saying that they'd got information about the crime scene. Chris Todd, Court TV, so Chris Todd's an author, Court TV on the 3rd of December of last year gave very graphic details on Court TV about the crime scene photos that he'd been sent, that he'd received from a source. That's on Court TV with Vinnie Politan. This is no conspiracy theory. This is there on Court TV. Do Court TV check the sources? I assume so. And Barbara MacDonald, the podcaster, and she works for Court TV as well. Some kind of, I don't know, correspondent, journalist, whatever. She's seen a bunch of crime scene stuff. And she said from a long time ago, investigators gave her crime scene information a long time ago. She said that on Court TV in September. I've played that clip many times. Played the Chris Todd clip the other day as well. So if you missed my videos from the last few days and you don't know what on earth I'm talking about, just go and check back those videos. I try to keep my videos short so that they're, easily watchable. And it seems that the bullshit that has come out, that Andrew Baldwin so terrible for allowing this leak to happen. Well, the leaks that allegedly happened from Andrew Baldwin's office, well, they'd already been leaked. So tell me again why the attorneys were disqualified with no hearing, no notice, and by notice we mean legal notice. Tell me again why she gave them an ultimatum on October the 19th and said, you either withdraw, which Brad Rosie never did. Or I'm going to disqualify you in front of the world's cameras, because that one and only time she allowed cameras in her courtroom, that one and only time. I wonder why, because she was planning it. And then she came out giving an Oscar-winning performance, saying, oh, this is an unexpected turn of events, looking very frazzled. No, she looked displeased because the attorneys didn't do what she thought they would do. She thought they'd come out fighting, and then she could give them a tongue lashing and disqualify them in front of the world's cameras with no legal notice, no opportunity to have brought witnesses, which they would have brought. So now there's a whole bunch of people fighting Richard Allen's cause, not because they think he's innocent, necessarily. I mean, some might. His attorneys, his rightful attorneys, Brad Rosie and Andrew Baldwin, I mean, it's very clear that they believe he's innocent. I don't believe that they would have done anything like, offering to work for free in a very complex case, headed straight for trial, having put in above and beyond, whatever you think about the memorandum from September, whether you think the ordinist theory is bullshit or whatever, it doesn't matter. That doesn't matter. The point is, they've gone above and beyond to fight for him, to show that there's potentially third-party guilt there, to show that there is clearly reasonable doubt in this case, to show that lies were told in order to get search warrants granted. And if the prosecution and the judge felt that there was absolutely no way that a jury would believe any of this crap that the attorneys are trying to feed people, if Slick Nick McClelland believed that the jury would just not buy it whatsoever because it's so crazy and it's so out of left field, wouldn't he just say, "No, let's go to trial. I'll see you in court on the 8th of January. Let's go. Let's go. I'll see you in court because I know I'll win." If the prosecution really had damning evidence against Richard Allen that could blow that defense out of the water, there is no way that Slick Nick McClelland would have thrown in the towel, would have put the idea in Francis Gull's head, because I'm prepared to say that it's all him. It's all him, in my humble opinion, allegedly, and all that stuff. He would have just said, what a load of bollocks. I'll see you in court. Being very smug, thinking, we've got a bunch of evidence that it'll just blow this whole ordinance thing out of the water. Nobody's lied. We've got the evidence to prove it. They've just said, I'll see you in court on the 8th of January. Happy Christmas. Happy New Year. We'll see you in court. But no, didn't work out that way, did it? Because he's scared. And listen, it doesn't matter whether you think Richard Allen is innocent. It doesn't matter whether the attorneys and the media people who are standing up for Richard Allen's cause believe he's innocent. That's irrelevant. This, as I keep saying, this right now is about due process. It's about fairness. Who else feels like our hands are tied? I do, but then I'm thousands of miles away. This is the only thing I can do. Is to keep talking about it. It's the only thing I can do. The people who've got some sway here are the good people of Indiana, are attorneys, people from the media, and hopefully enough pressure can be put on the Supreme Court of Indiana to for them to, I don't know, remove Francis C. Gull and reinstate Brad Rosie and Andrew Baldwin. That's kind of what we want, really. I think that's the only thing that I want at this stage. That's the only thing I want at this stage. I want her gone. And I want at least Brad Rosie reinstated. If a case can be made, if a case can be made that regardless of what leaks have come before, that Andrew Baldwin's security was lax, all right, if that can be proven, and Andrew Baldwin holds his hands up to that and says, yeah, it's a fair cop, Gov, I was lax, a friend betrayed me, etc., etc. Well, Brad Rosie did nothing. Brad Rosie works for a different firm in a completely different office. There is there's
for you guys to start being journalists.
Before
I'm going to play that in a minute. Hold on. Hold on. I'm going to play that in a minute. I clicked it too soon. But yeah, reinstate Brad Rosie. Get rid of that absolute scary guy, William Labrato, because he's just Francis Gull's lackey. Robert Scremin? What about Brad Rosie and Robert Scremin as a team? I don't know. I don't know. But I don't think Andrew Baldwin's done anything wrong, honestly. I don't think he's done anything wrong. I think he's been set up. Now, whether that setting up has been Mitch Westerman's doing, whether there was even a leak, whether there was even Mitch Westerman has sworn an affidavit, you know, that he did take photos of photos from the conference room in Andrew Baldwin's building, in his offices. But did he? Did he? Because you see, the thing is, Andrew Baldwin has only got Mitch Westerman's word that he stole those photos or took photos of those photos. Andrew Baldwin might believe that Mitch Westerman did what he did, but maybe Mitch Westerman didn't. I don't know. I don't know. I think we're being fed a pack of lies. I really do. I really do. But someone paid Westerman. Yeah, I think so. I think so. But it really doesn't matter whether you think that Richard Allen is innocent or guilty. I don't know. I honestly don't know. But that's irrelevant. Irrelevant. This is about fairness. This is about living in a civilized society where everybody has a right to a fair trial and has a right to attorneys of their choice. And it's exactly the same in my country as it is in the United States. We have the very similar legal systems. Doesn't matter whether it's in the United States or me, anywhere in the civilized world. This is just an absolute travesty of justice. Complete travesty of justice. But we'll move on to the next item, which is the amicus brief. And as Andrew Baldwin said, it's time for people to become journalists.
Andrew Baldwin left the courthouse. 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Muted. I like the intro. I've been using it a lot. Maybe I've been overusing it. Thank you, Krista, for the 19.99. That's very kind of you. Thank you so much. Thank you. Thank you. We are watching. We are watching. We do see what's going on. We absolutely do. Okay, next item. I'm just reading. Just reading Reddit a minute just to see if there's anything new. I read that from Delphi Docs. It's just easy. It's easy. Okay, so we've got nothing new. Right, amicus brief. Okay, so this was posted today. Okay, from the Media Coalition. This was written by attorneys on behalf of the Media Coalition. Now, before we read this, I do need to read the little section here, because this hasn't been accepted quite yet for administrative reasons. So, okay, so it's a bunch of media companies have got together, and then they've got attorneys acting on behalf of them who wrote this brief. So this is what the Clerk of Court has said as to why they can't accept it just yet. Certificate of service does not indicate service of actual document and refers to federal case management system. So, I don't know. Motion for amicus curiae. Certificate of service does not indicate service of actual document and refers to federal case management system. Brief lacks table of contents and table of authorities and actual cover page. Also, certificate of service is non-compliant. So basically, it's an admin error. Whoever submitted it has put the wrong, I don't know, refers to a federal case management system. They've not put a table of contents in. So the Clerk of Court of the Supreme Court of Indiana, I guess, has got a right to say we want them in a standard format. We want everything standardized. So they've basically got to take it away and correct those things, and then they can re-upload it. So it's not thrown out or anything like that. They can just re-upload it in its standard form. So it's not going to affect the content, like the substantive content. So I'm going to read it as it stands, even though there will be a slightly different version that will come out in due course, maybe even later today, I don't know. So again, it's Richard Allen as the realtor or relator. And the respondents are Carroll Circuit Court and the Dishonourable Francis G. Gull. It's Seagull. It's Seagull. Remember the bird that flaps about near the ocean. Seagull. And no, I'm not being facetious. Her middle initial is C and her surname is Gull. So there's that. All right. So again, this isn't accepted just yet. It has to be corrected. And like I said, the substantive content isn't going to change. Okay, so brief of amici curiae. Oh, the legal people, they just love their Latin, don't they? What does that mean in English? I suppose I could look it up. Okay, so this is by the Media Coalition, so the Indiana Broadcasters Association. So when Andrew Baldwin said, it's time for you to start being journalists, well, listen, the journalists have started being journalists. Good on them. Listen, there's so many people behind Richard Allen's cause. Now, it's warming to see that people are standing up for corruption. They're standing up for somebody who potentially has murdered 2 children. But people can realize that this is not about innocence or guilt at this stage. This is about if this is allowed to continue towards anybody, it could be you next. It could be your wife, your husband, your father, your mother, your son, your daughter, your cousin, your best friend. It could be anybody that you care about next, anywhere in the civilized world. You know, if we just want to throw the law away and just, you know, let anarchy reign, well, I'm all for a bit of anarchy. I'll win. But come on, right? Come on. We don't want that, really, do we? We don't really want anarchy. We really don't want that. Seriously. We want due process. We want justice for Abigail Williams and Liberty German. The only way Abby and Libby will ever get justice is if the right person is convicted. That may be Richard Allen. We don't know yet. But also that that person gets a fair trial. Or if they don't get a fair trial, there's no hope. There's no hope for anybody. That's not justice. It's not justice. Okay. So the Indiana Broadcasters Association, Hoosier State Press Association, the American Broadcasting Companies, Inc., So DBA, ABC News, EW Shrips Company, WRTV Shrips, Gannett Satellite Information Network, LLC, the Indianapolis Star, Next Star Media. So Next Star, they own like News Nation, a bunch of other channels. I know that when I play News Nation clips, it's Next Star that always copyright claims my video. That's why I know that that's the parent company of News Nation and a bunch of others. Okay, so WXIN, WTTV, Tegna Inc., WTHR, collectively the Media Coalition. So all these different companies have all got together, right? So the Indiana Broadcast Association, Hoosier State Press, American Broadcasting Companies, ABC, all these have all got together. All right. Anyone seen Robin Lane's latest mudslinging video? No, I haven't. If you want to drop the link in the chat, or if a mod wants to, you're welcome. Okay, by council. So the Media Coalition, all these companies have got together to form the Media Coalition, and they've got attorneys who are acting on their behalf. All right, you got it. Great. Submits this brief of amici curiae in support of realtor Richard Allen's verified petition for writ of mandamus and prohibition. So they're supporting the writ. Which writ? Because there's two. There's two writs. I know the two separate writs because they've got two different case numbers. But anyway, let's does it say? I don't. Okay, case number. Oh no, maybe they've both got the same cause number and different file numbers. I'm not sure. But yeah, this has got the same cause number as the one that's due today. So I'm assuming that it's the one that's due today that they're supporting. I need to dig out the other writ and see whether they've both got the same cause number. They've definitely got separate file numbers. Okay. But there is two different writs. All right. So, amici respectfully urge the Supreme Court. Does amici mean friend? Right. Amicable. I'm going to look it up. Amicus. Meaning. An impartial advisor to a court of law. Okay, so it's an advisor. So, a friend of the court. So, the Federal Republic of Germany filed an amicus brief arguing that the convention was exclusive. So, an impartial advisor to a court of law. All right. Okay, glad we got that sorted. You can't drop Robin's link. Is it on her channel, Mike? Because I'll just go and look at it later if it is. Friend of the court. All right. So somebody impartial who is maybe got a concern, wants to give the court some friendly advice, maybe. All right. So amici respectfully urge the Supreme Court to grant the petition because the status quo threatens key democratic values and trust in the criminal justice system. It's on Robin Lane's channel. All right, I'll go and watch it later. In seeking public access, amici act as surrogates for the public. So remember, this is the media talking. Okay. The United States Supreme Court has aptly explained the media's important role. In a society in which each individual has but limited time and resources with which to observe at first hand the operation of his government, he relies necessarily upon the press to bring to him inconvenient forms the fact of those operations. And when cameras are not allowed in the court, we rely on journalists to communicate information from the courts to the public. I know this because I live in the UK, where cameras have not been allowed in courts forever. Now, judges are starting to trial cameras at sentencing hearings, and I'm hearing good things. Judges generally like it. So hopefully, at some point in the near future, we're going to get televised trials here in the UK. Wouldn't that be good? You know, this day and age, you'd think that wouldn't be too difficult to arrange. And Indiana is, I think, one state in the US that has only recently been, allowing cameras in. And of course, it's all at the judge's discretion anyway. All right. Okay. Great responsibility is accordingly placed upon the news media to report fully and accurately the proceedings of government, and official records and documents open to the public are the basic data of government operations. With respect to judicial proceedings in particular, the function of the press serves to guarantee the fairness of trials and to bring to bear the beneficial effects of public scrutiny upon the administration of justice. Okay. The trial court's orders which exclude judicial records from public access without process or remove them from the CCS altogether, so the CCS, the court system, significantly restrain the media's news-gathering activities regarding a matter of the utmost public importance. If the trial court's handling of judicial records stand, the media cannot serve its pivotal role in democratic society, and the public will remain in the dark. Yes, but that's what a corrupt system wants, where a judge is acting like a dictator. That's what they want. They want the public to remain in the dark. Okay. Amici respectfully request that the court grant the petition. So, footnote here. The Media Coalition acknowledges that the trial court ordered that certain documents be made public on the docket per its order issued on November 14th. Okay, so that's 2 days ago. While the order resolves some of the access concerns stated in the petition, the order does not resolve all the concerns. Go and see my video from yesterday. They're speaking my language. And it appears that the mere filing of the petition spurred the order. Yes, it did. The petition remains important in ensuring complete adherence to the access rules, as well as to address the issues that remain unresolved by the order. Okay, so the argument. The trial court's handling of court records is contrary to Indiana public policy favouring open government and the Indiana and United States Constitution protecting access rights. Okay, so correction of the trial court's errors is necessary to ensure government transparency and accountability, neither of which a dishonourable judge wants to have to deal with, which is especially critical in criminal matters. So I'm not going to read the references here. You can, if you just write in Nebraska Press Association versus Stewart and that number 1976, it'll come up, I guess. That information about it will come up. Explaining that the press is the handmaiden of effective judicial administration, especially in the criminal field, and a guard against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism, which they all need. All right, listen. Generally speaking, I back the blue. Right? We need a police force. We need a judicial system, or else anarchy. If you want anarchy, then go for it. All right. But when there's corruption of any kind, it undermines the very fabric of society, because it ends up with people not trusting anything. The more bad actors there are in government, of which there are many, especially in my country, good Lord, in the police, in the courts, all those bad actors, they undermine the system and the people who are trying, who genuinely go into those jobs to protect and serve. Because I know some very good police officers. I really do, genuinely do, right? But the bad apples, they corrupt the whole system, and they make mistrust where there need not be mistrust, and they all need removing. Unfortunately, when you get to the higher levels, it's easy to fire a police officer who's doing a bad job. But when you get higher and higher up in government, including judges and beyond judges, then you've got a big problem in getting them out. Anyway, consistent with these principles, the General Assembly expressly recognises Indiana's public policy that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees, of whom the Dishonourable Francis C. Gull is one. Right, okay. All right. So we want openness requires compelling evidence to overcome this presumption. So that's commentary to Rule 6. Access to public records will liberally construe to implement this policy. The burden of non-disclosure falls on the public agency. Apart from the well-reasoned policy considerations, the public interest in accessing judicial records has constitutional dimensions. The media, as representatives of the public, are presumptively entitled to judicial documents, not leaked ones. Listen, not leaked ones. When there's an active investigation underway, we expect law enforcement to protect the integrity of that investigation. So when investigators are leaking crime scene photos of children to podcasters, I've got a problem with that. All right. Okay. And I don't know why Court TV don't seem to have a problem with that, and people like the Murder Sheet clutching their pearls about the leaks that the defence have done when, hold on a minute, didn't they get leaked information? All that Kegan Klein stuff, this Ron Logan search warrant, wasn't that a leak from them? I don't know. You tell me. All right. Okay. The media, as representatives of the public, are presumptively entitled to judicial documents and proceedings under the First and 14th Amendment of the United States Constitution. Okay. It is clear that the courts of this country, and my country as well, recognise a general right to inspect and copy public records and documents, including judicial records and documents. Kyle's just woken up.
What were you saying about me?
I said you've just woken up.
Oh, yeah, from a nap.
Went for a nap when he came in. Okay. The Indiana Constitution, similarly, and perhaps more so, protects public access and key news-gathering activities. No law shall be passed restraining the free exchange of thought and opinion or restricting the right to speak, write, or print freely on any subject whatsoever. Okay. In light of Indiana's constitutional protection of the free interchange of ideas, this court has assumed that a material burden on news-gathering ability could violate the Indiana Constitution. The Kylester. Okay, considering Indiana's policy favouring public access and the constitutional implications of restricting access to judicial records, the public's and media's interest in accessing judicial records is not something to be taken lightly. In disregarding the access to court records rules and trial rules, the trial court has improperly restrained or outright prevented the public and the media's access. Totally. But that's what dictators do, right? That's what dictators do. The trial court's violations of the ACRs, the access to records, and trial rules significantly undermine the public's access rights and the media's news gathering functions. As explained in this petition, the trial court improperly removed publicly filed documents from the CCS and excluded others from public access. She's still trying it on. Listen, she's still trying it on. The memorandum from September 18th, she states that it's still sealed because the rightful attorneys, Andrew Baldwin and Brad Rosey, didn't file a redacted version. If you want to tell me what should have been redacted in that document, I'm all ears. Okay. But every word of it, I don't see anything that needed to be redacted. But again, that's just me. There was no children mentioned, apart from, obviously, the victims and the juveniles who were witnesses, but I don't think the memo even talked about them very much. So all the people named were adults. There was no dates of birth, no telephone numbers, no addresses that I saw in there. I'm not sure what else Judge Francis Gull deemed to be needing of redacting. Maybe she needs to explain. I don't know. Or maybe it's just an excuse because she doesn't want people to read it. But it's out there. It's in. Listen, it's there in the documents filed with the Supreme Court of Indiana. So if we didn't catch it the first time round and you don't want to go to the many live streams that spent hours and hours and hours going through it, then just go to the Supreme Court of Indiana because they've got it there. The entire thing unredacted in their files. So the Supreme Court of Indiana don't think it needs to be redacted, do they? I don't know. First, the trial court's removal of filings from the CCS is never allowed, and for good reason. The trial court lacks any authority to remove filings from the docket. This is true, even if the trial court deems a filing improper. Even improper filings are public record, and the trial court's findings of impropriety does not strip the filing of its public importance. The Franks Memorandum, from the rightful attorneys filed on September the 18th, is a key example. Frank's filings attack probable cause affidavits by asserting that the preparing officer misled the court regarding the existence of probable cause. Franks versus Delaware, 1978. I'm becoming very, very well acquainted with that reference now. A criminal defendant's attack on the foundation of his arrest, even if somehow improper, is newsworthy and deserving of publication. It is. It is. Yeah, if everybody thinks it's improper, if everybody thinks it's a bag of horse crap, it doesn't matter. It's still got to be out there so that people can discuss it and call it a bag of horse crap. All right? You've got a right to call it a bag of horse crap if that's what you think it is. But you have a right to read it and you have a right to discuss it. This is the point I'm making. Okay. Unilateral erasure of filings from the public record erases history. There has not been a truer word said in the entirety of this case. Unilateral erasure of filings from public record erases history. That's exactly what Francis C. Gull has tried to do by removing Brad Rosie and Andrew Baldwin. She's tried to airbrush history from Richard Allen's case because she didn't like what she was seeing. Or rather, Slick Nick McClellan didn't like what he was seeing, because it's my humble opinion he's the one pulling the strings. Just my opinion. Second, the parties cannot just agree to exclude public records from public access. The ACR rules expressly prohibit that. ACR Rule 5, see also Citizens First National Bank, see versus Cincinnati, blah, blah, blah. The judge is the primary representative of the public interest in the judicial process and is duty-bound, therefore, to review any request to seal the record or part of it. Instead, the request to prohibit public access to records that otherwise would be public accessible, notice and the public hearing are required. So a judge can't just come along and seal stuff because she doesn't like it. She can't do that. There's rules in place for a good reason. The public hearing provides necessary sunshine. Francis C. Gull doesn't like sunshine. I think she's some kind of vampire or something. I don't know. She doesn't like sunshine at all. Sits in the dark the whole time. And she likes everybody else to stay in the dark. That's what she does. Public hearing provides necessary sunshine. Its absence cloaks the judicial process in secrecy. Yeah, it's what she loves. The public hearing also ensures that the presumption of access has been overcome before a record is excluded. Got it? Can't just come along and seal stuff because you don't like it. Rules for a reason. And no, anybody who wants to come along and say the judge can decide because the judge is in charge of the law in the court. No. The judge is a public servant. The judge is there as an arbiter. The judge is there to ensure that the scales of justice are balanced. And it's a very important office to hold. It's a very important public service job. It can't be just done by any Tom, Dick or Harriet, right? It requires a very special person who's able to understand the law, but to remain completely and totally objective in delivering the law. And the way that she does that is by implementing the law of the land, and in this case, Indiana state law. That's what she does. That's what she's meant to do. That's a judge's role in society. They hold those scales of justice and ensure that they are balanced. Anything less is injustice, period. Okay. Process ensures that matters of public concern stay public unless extraordinary circumstances warrant otherwise. Okay. Holding that court improperly delegated its duty to determine whether records should be sealed to parties. So that's relating to that thing there. The public concern is especially acute here, where the improperly excluded records are from one of the most high-profile criminal cases in Indiana history. And because it's high-profile, all these things are coming to light. My question is, how many other cases has Francis C. Gull behaved in this way? That, you know, cases that no one's ever heard of, ever likely to hear of. Is this something that she does all the time? I'm just curious. Is this something she does all the time? And she just thinks that she can dictate over the court and disregard the law. It seems likely that that's what she's been doing. To me, just my opinion. Third, the trial court's decision to upload the public documents to a zip file online or a Google file, Google Drive, rather than making them publicly accessible on the CCS is a woefully inadequate substitute. So this is referring to the 118 documents that were all sealed and they were all released at the same time. I've shown you the Google file. Let me show you again. The Google file, Delphi Docs. Oh, it's been taken down. Oh, it's gone. It's been taken. Oh, no. It's just taking a minute to load. Here we go. This is 118 documents. 118 documents that were unsealed all at the same time. And there's very few of them that you can't even see what they are. Like all these, like what's that? What's that? And you can click on it and say, oh yeah, that's a photo. All right, that's some kind of document. Okay, so you can look at the preview to try and work out what it is, but you have to open each and every document to work out what it is. And because they're all posted at the same time, they all have the date of June 27th, 2023. So you can't chronologically go through and work out, you know, what happened when, and what document goes with which other document, and what decision was made. And you can't work it out. It's like a big jigsaw puzzle. So instead of just putting it on the court system, so, you know, because all of that stuff would have surely have been on the court system, but just all sealed. Surely that's what happened. And once they decide to unseal them, then they just unseal them. Surely that's what should happen, rather than just putting it all on a Google Drive. I mean, how secure is a Google Drive, honestly? Surely the court system's safer, more secure than a Google Drive. I don't know. But yeah, that's what happened on June 27th when these documents were released. Well, I think it was released on June 28th. They were all uploaded on June 27th, and then they were on the Google Drive went live on June 28th. Instead of just doing it the normal way. So that's what they're referring to here with these 118 documents. Okay. As explained in the petition, the 118 documents in the zip file were filed over several months. Each document in the zip file is dated 6/27/23, as you've just seen, and the file names have no clear identifying information. They don't. A few do, to be fair. A few do. Alan 3 PDF. Alan 4 PDF. Alan Motion, PO Discovery. Okay. So that's Alan Motion PDF. I mean, Alan State's response. All right, State's response to what? So some of them you can kind of, all right, that could be interesting. I'll click on that. But some of them have just got, like, they're just numbers. I mean, no, it's ridiculous. Ridiculous. So that's what they look like for those who haven't seen it before. So this is what this is referring to. Okay, file names have no clear identifying information. Even if the files were labelled clearly and organised chronologically, however, that would still be insufficient. An official record of the trial court, the CCS, is where the public goes to get information about cases and to view court records. A central and consistent repository rather than a piecemeal approach, i.e. some records are located at X, so some records are now on the Google Drive, some of them were somewhere else. It's like, oh, ridiculous. Others are located at Y, fosters meaningful public access. Okay, see also, they've cited Loretta Rush. Loretta Rush is the Supreme Judge. She's the one making the decisions. I love it that they've referenced her. So this is what Loretta Rush said. Online access to courts is one way to improve accessibility. Indiana Capital Chronicle, August 28, 2023. Love it. Love it that they've referenced her. Citing my case as an example of an online portal that fosters a more efficient and transparent legal system. The trial court should be required to make the 118 documents publicly available on the CCS itself. Well, she did issue an order gaslighting the court clerk yesterday. If you saw my video from yesterday, She blamed the court clerk for not doing it. She went, "Oh, I've just been reviewing the system, and the court clerk doesn't seem to have done this yet." Oh dear, she's not only a dictator, she's also a gaslighter. Hello, Noodle Doodle. Are you okay? Am I being too loud? Oh, Noodle says I'm being too loud. Noodle thinks I'm shouting. I'm not shouting, Noodle Doodle. You can go back to sleep. You're a good boy. You're a good boy. He's a good boy. Oh, Cassie's here now. She's jealous. All right. Okay. Granting the petition would serve the significant public interest in this case and denying it. I mean, she's already admitted she's wrong. Listen, by granting that order, gaslighting the court clerk, and also unsealing that letter, right, that we've read, she's admitted. She's subtly admitted that she was wrong in doing that. Okay. She realizes. She's trying to subtly correct her mistakes now, thinking that no one will notice. Okay. All right then. Okay, Fran. It might work for some people, but yeah. I wasn't born yesterday. Didn't come down with the latest rain shower. All right. Okay. The significant and legitimate public interest in this case is undeniable. Already, the trial court has received numerous requests for access to judicial records and for cameras in the courtroom. The public interest in this case is not going away anytime soon. Are you listening, Francis? We're not going away. The world is watching. All eyes on you. All eyes very firmly on you. We weren't really taking much notice in you before, till you started being a very problematic human being. Oh dear, she's her own worst enemy. All right, maybe Slick Nick and William Labrato aren't great bedfellows. They're bringing you down, Francis. Bringing you down. All right, the public, just my opinion, of course. The public interest in this case is not going to end anytime soon unless the petition is granted. The integrity of the judicial system is at risk. It is in every civilized society, everywhere in the world. Secrecy of judicial action can only breed ignorance and distrust of courts. Exactly. And I could have written this. They've been reading my mind. I don't know how far away is Indiana from me, but obviously my brainwaves have been going over the airwaves and infiltrating people's brains, because I exactly not just what I've been saying, it's what a lot of people have been saying. Okay. And then other people are going, he's guilty, he's a murderer, why are you defending him? Not defending Richard Allen. Richard Allen's a subject this time. Next time, it could be you. Next time, I'll defend you. Even if you were rotten to me in my comments, I'll still defend you. Because this is wrong. It's wrong to happen to anybody. Okay. Distrust of courts and suspicion concerning the competence and impartiality of judges, and free and robust reporting, criticism and debate can subject the criminal justice system to the cleansing efforts of exposure and public accountability. The history leading to Realtor's arrest, coupled with the nature of the underlying alleged crimes, murder of 2 children, underscores the need for transparency. The death of any child is a matter of the keenest public interest. The Delphi community and the broader public deserve access. Even if access to every judicial record is not ultimately granted, the ACR rules must be followed to protect the public's trust in the system and ensure fair proceedings. With respect to judicial proceedings in particular, the function of the press serves to guarantee the fairness of trials and to bring to bear the beneficial effects of public scrutiny upon the administration of justice. She doesn't want public scrutiny, unfortunately. Has she? She's had a couple of cases overturned on appeal recently. Has she indeed? Has she indeed? That's interesting. Granting the petition would facilitate key news gathering activities and ensure that access and process prevail and promote the public confidence in our judicial system. Anywhere, any judicial system in the free world. Conclusion. Amici respectfully request that the court grant realtor Richard Allen's verified petition for writ of mandamus and prohibition. So it's the first one. I'm confident that it's the first one. The deadline due today. Deadline due today. Brilliant. Brilliant. Gonna play this again. Just cause.
You guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Where am I going now? There we go. Okay, so that's the latest. So let's see if there's anything popped off while I've been reading. Delphi Docs. Oh, got something new here. Oh, Gull filed response just before the deadline ended. No way. Breaking news. Where's the response? Where's the response? I want the response. Sitting on pins and needles, wondering what she had to say. Took it to the very last minute. What time is it in Indiana? So it's 9 o'clock here. So 4 o'clock. 4 o'clock in Indiana. Gonna drag this out every step of the way. I said that. I said she'd go all the way up to the deadline. I said that. Where is it? I don't know. It'll be with the Supreme Court of Indiana, but it's in the Supreme Court's hands. Certificate of service electronically served. Christopher Stake, Matthew Gutwine. Party, Francis M. Catino Gull. So C stands for Catino. Oh, we need it. We need it. We need it. Has anybody got it? 3:58 in Indiana. Maybe the deadline was 4 p.m. I don't know. I don't know what's counted as close of play. Like we normally close of play business is normally like 5 in the UK. Thank you, Jellin Harding, for the 149. That's very kind. It's weird that YouTube tells me that that was your 5th super chat. I don't know how long it counts. I thought she had to the 27th. No, pit bulls across America. No, I said this at the beginning of the stream, but I'll say this again for people who maybe are still confused or who've just come in partway through. No, there's 2 different writs. All right, let me explain this by doing this. Okay, I'm going to have to stop sharing and reshare, doing it like this. Okay. All right. Have I got it?
Oh, God.
Hold on, there's
Problem.
what?
Noodle and Cassie. Same again. The other night.
Oh, dear God.
Tilly. Oh my God.
Right. Right. Cassie's in season. Okay. Nude.
Well, they need some help, so.
What help? What help do they need?
Just rolling about.
Cassie.
Tilly, come here. Tilly.
Right. This is the situation we've got at the moment. Cassie's in season. Noodle was neutered 10 weeks ago, but has not lost his sex drive. He's lost his capacity to impregnate. So he's firing blanks. But yeah, they keep mating. So it's now the third time that I've seen them mating. And Tilly thinks it's a spectator sport. So Tilly jumps around them, right, agitating them both. And if you've ever seen dogs mating, they tie for like a few minutes. There's a tie actually goes on. So, the other night, Kyle came running upstairs saying, Noodle and Cassie are stuck together. Bear in mind, Kyle's 21. Okay, Kyle's 21. Right. And I thought he meant they got stuck in the tree outside because Cassie climbs the tree outside to get to birds. And Noodle tries to follow her. So I thought that they got somehow hung off this tree and they were stuck. Right. And I dashed downstairs and they're there stuck together. And it's like the mating, Kyle. There's nothing I can do about that. At least he's firing blanks. Because eventually he'll lose his sex drive, you know. And but yeah. So hopefully he's firing blanks. I mean, he's not got the equipment to produce sperm. But anyway, all right. Okay. But I really thought that somehow they got outside and they were stuck in the tree, like being hung by the collars or something. I was thinking, oh, good God, they're going to, you know, I literally dashed, like nearly fell, dashing downstairs as quickly as I could to save these two dogs who were hanging from the tree. But no. All right, what am I showing you? Okay. So this is the writ that the deadline was today. So this is how it's got confusing. Just let me move this. So this was issued to the Supreme Court of Indiana. Okay. And the Supreme Court of Indiana wrote back saying that I had a super chat before. Hold on, let's have a look. Hey, Serial Boomer, thank you for the $1.99. That's your 5th super chat as well. Oh dear. Okay, so let me find. Do I have? Maybe I don't have it to hand. I thought I had it. No, maybe not. All right. Okay. I'm not going to try and find it. All right. So this was submitted. And Loretta Rush, the supreme head boss person of the Supreme Court of Indiana, gave Francis C. Gull till the 9th of November to either comply with this or to explain why she couldn't, or, you know, to file a response. She then requested 5 business days. So that's a week because you don't include weekends. So she was given the deadline of today. Meanwhile, a second writ about something else was sent to the Indiana Supreme Court. They gave her till the 16th, so today. So she wrote back and said she can't do it. You know, she's already got one thing and, you know, she's very, very busy. I covered all this in live streams. I covered it all. I read it all out on live streams. Could she have an extension until the 27th? Because there's Thanksgiving, which is a holiday. It's not a business day. And also there's Lincoln's birthday. Which, yes, it's February, but in some counties in Indiana, they celebrate it in November. So given that there's 2 weekends and there's Thanksgiving and blah, 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 they granted her until the 27th. So the deadline for the first writ is today, and the deadline for the second writ is November 27th. And they are different. The different file numbers, so the different, completely different documents with different deadlines. Yeah, she needs time to manufacture a non-existent transcript. So, do you want to be reminded? I talked about this in my video yesterday, but let's remind ourselves what this writ relates to. Okay. Statement of relief sought. So this is what they wanted to do. Richard Allen's realtor requests that permanent writs of mandamus and prohibition be issued. 1. Mandating that the trial court reinstate the following court records as publicly accessible documents on the CCS. Okay. Allen's September 18th Frank's memorandum. So she wrote yesterday, well, I talked about it yesterday, possibly the day before. She wrote that she couldn't unseal it because the attorneys, the rightful attorneys, Rosie and Baldwin, had not redacted it. So as I talked about yesterday and today, what is in that needed to be redacting? Nothing. So there we go. But she's still not complied with that. Allen's October 25th verified notice of continuing representation. Motion to disqualify. So she said that she's put those back, but she's still not acting on them anyway. So that's notice of continuation from Rosie, and then that one's Baldwin. Alyssa Ann, member for 10 months. Thank you, thank you, thank you. And Only Grand's member for 21 months, nearly 2 years. You must be one of the OG members. No super chat, just bragging because I'm broke. Oh, dear. Must be only the courts that have the holiday of Lincoln's birthday in November. I've never heard of it ever before. No, apparently it's just what some counties in Indiana do. Donna B, member for 1 month. Thank you, thank you. Okay. So those have been put back, but she's choosing to strike them from the record because her rationale is because they were submitted by attorneys who are no longer of record, because she illegally and immorally disqualified them with no hearing. Okay. So that's why she's striking them from the record. So they're there, people can read them. However, she's not going to do anything about it. Okay. And the transcript. No mention of that. So that's still outstanding. Prohibiting the trial courts from ordering the removal of any court records filed in this case from the CCS and the electronic file. Prohibiting the trial court from excluding from public access any court records without the requirement of the access to court records rules being satisfied, including but not limited to every court record excluded from public access must be accompanied by an ACR form specific to Rule 5 grounds upon which exclusion is based, and unless everything in court record can be properly excluded from public access, a public access version and a non-public access version of the document must be filed. So that's just kind of standard stuff that judges shouldn't need to be told, but clearly she does need to be told. Okay, mandating. So these things she's actually done. Mandating that the 118 documents on the zip drive must be made publicly accessible on CCS. So she's done that. Mandating that the court records referenced in the June 28, 2023 order that maintains excluded from public access by agreement be made available for public access 72 after the writ. So she says she's done that. I haven't seen it, but she says she's done it. Oh, they're untied now. They seem to be untied now. We've actually got 2 separate dogs now, so that's good. Okay. Oh, I know what noodle came into me before. Right. When Cassie flirts with him, Noodle runs to me for reassurance. Because she's properly been badgering him. So that's what he came running in for before. I thought it's because I was shouting. I thought he was scared because I was shouting. He was scared because Cassie was after him. He's traumatized, the poor thing. Okay. Mandating that the court records... I've read that. Mandated that the June 20th filing from the Carroll County Sheriff and the July 5th, 2023, the letter from the Department of Corrections inmate be made available for public access. So she's done that. Or we've seen that one. We've read that letter from the DOC inmate. We've read that. So these two will all also be hitting the public very soon, because she said she's done it, or she's going to do it. Okay. So she's done some of these already. So I want to read her response. I don't know whether we'll get to see her response today or not. It's up to the Supreme Court of Indiana to release it. Don't let me don't like sharing my screen like this. It's weird doing it like that. Let's have a look. If any of the good people from Delphi Docs has got it. Oh, I'm not sharing, am I? Hold on. See the response here. Just checked the case summary and got so excited, didn't realise I checked it soon after it was filed. Looking forward to reading it. I need to get a life because I'm refreshing the page every 2 minutes. That's what I do. Yeah, so it's not out yet. Paper Chaser, member for 13 months. Yeah, Franny, TikTok. Sleuthing Sandals, member for 18 months. Proud to be part of the fun. Oh, dear. Yeah, so it's down to the Supreme Court of Indiana to release it. They might not release it today. Oh, you're reading it? Are you actually reading it, Marissa? Has it been released? It's there. Okay. Supreme Court of Indiana. See if I can get it. It'll only be a few minutes before Delphi Docs has it, but some of these things I can't do because I'm in the UK. Like some court systems let me on, some don't. I can put my VPN on, but it slows my whole computer down. I don't like doing that when I'm on a live, because it slows my whole thing down. Okay, where am I going? Search case, rules of court. Where do I go to get it? Is that right? Yeah. If counsel doesn't want to quit and defendant doesn't want them to quit, there has to be a public hearing. There does. There absolutely does. You're right. There absolutely does. And there wasn't one. It was nonsense. Absolute nonsense. Somebody replied to me on refresh post, Michelle. It's up on DD. You replied to me on Reddit, somebody. That's funny. No one else will know what they're on. What we're on about. Sitting on pins and needles. Where is it? Can somebody email it to me? What's happening with the pro bono offer? She disqualified them. She's not letting them work pro bono. There's been 2 new attorneys, William Labrato and Robert Scremin. Gull fights the law and the law wins. Oh, that's good. That's clever. Yeah, Gull refused their participation under any circumstances. What I don't understand is that nowhere in the Frank statement was the so-called 43-second recording mentioned. Does anyone have a theory on this? Well, did they need to mention it? Like, we all know that there is that video out there. I'm not really sure why they would need to mention it in a Frank's memorandum. Because the whole idea was putting the idea of third-party guilt that some other dude did it, or dudes. That's their trial strategy, that Alan's not guilty because someone else did it. So a lot of that document was explaining that. But to get the Franks hearing, it was the PCA was illegal and immoral because Liggett, who was a detective at the time, lied. No, the BG video isn't false. No, I don't think it is. Yeah, there has been a lot of typos, but honestly, listen, when you're compiling documents of that size, especially when you're a concepts person, typos happen. When I wrote my PhD thesis, it was, I don't know, maybe 256 pages, something like that. And it was full of typos. And my examiners went through and corrected all my typos. Because when a document, I mean, it might be different now, but in the old days, before computers got good, the spell checker would only work for so many words, and the file was too big. There was too many words in the file for it to spell check. So I had to go through and try to find every misspelling. And obviously I failed dismally. I'm a concepts person, not a details person. And I'm guessing that Andrew Baldwin is very much the same. But nobody cares about typos. Who cares about typos except for people who don't have an actual argument? Just my opinion. I mean, obviously, if words are so badly written that you can't understand what they say, that's a bit different. But has anybody... Why has nobody shared it? Or maybe they have. Maybe I need to go out of it and come back in. Has anybody emailed it to me? I want to read it. Oh! Oh! Yes, here we go. Here we go. Boom. Somebody's got it. Boom. All right. Are you ready? Sit tight. Sit tight. Let me just download this for safekeeping. Okay. All right. Are you ready? I've got too many things open now. All right. Are you ready? How many pages is it? Oh, it's long. Oh, it's long. Oh, is it gonna really 18 pages? Let's read. Let's read. This chair makes my back ache. So there's that, but okay. A lot of it's contents and stuff that we don't need to read. Okay, respondent's brief in opposition to realtor's verified petition for writ of mandamus and prohibition. Christina, thank you for the $9.99 for my excitement. Oh. So this is by Matthew Gutwine and Christopher Stake on behalf of the Dishonourable Francis C. Gull. Okay, table of contents, table of authorities. So these are the cases that she's referenced. Oh, she's been a busy girl. Or at least her attorneys have been busy. So what's this? The rules. Oh, she's citing rules and everything. Oh, she means business. So we're already on page 5 before we even need to start reading. All right, you ready? Sitting comfortably. Respondent, the Dishonourable Francis C. Gull, Special Judge. Special in other ways as well. Okay, respondent, by counsel and pursuant to Rule 3F of the Indiana Rules of Procedure for original actions, rules, files her brief in opposition to Realtor Richard Allen's verified petition for writ of mandamus and prohibition. Okay, I can feel my blood pressure rising already. All right, Realtor fails to satisfy either the conditions precedent or the mandatory requirements to even seek a writ. Nor does the Realtor's petition warrant relief on the merits. Realtor asks this court to order respondent to unseal or to make available on the chronological case summary certain documents in this case. This court should deny the writ. Okay, Purple Agent member for 25 months. Deny. Yeah, exactly. First, by his own admission, realtor has not filed a written motion seeking relief from respondent. Original Actions Rules 2A and 3A4. This failure alone warrants this court to reject the petition. Second, for almost all the documents at issue here, realtor has not acted expeditiously. What? Original Action Rules 3A2. Realtor complains largely about events that occurred months ago. What? Just because you've been sitting on files that are months old is completely irrelevant. Oh, piss off. Oh, she makes me sick. Third, realtor has not attempted to demonstrate that denial of the petition will result in extreme hardship to himself. The fact he's sitting in effing Westville Correctional Facility is completely irrelevant. It is actually relevant to this writ, but just bear that in mind. Okay. Realtor has complete access to all the documents filed in this case, sealed or unsealed. He does. Well, does he though? His attorneys do. But that's not the point. That's not the point. That's not the point. And realtor has not demonstrated extreme hardship to anyone else. Original Actions Rule 3A5. Fourth, realtor's remedies available on appeal are wholly adequate. Original Actions Rule 3A6. Disputes about public access to court records are governed by the normal rules of procedure, evidence, and appeal, all of which are available to realtor. Okay. For these reasons, the petition fails procedurally. Just do your goddamn job, Francis. Just do your goddamn job. Follow the rules and stop effing around. On the merits, realtor's petition also fails. Most of the relief realtor seeks is now moot. Oh, it is because 2 days ago. Oh, wow. She's put those documents up so that she can then go, look, they're there. This is all moot. This is all moot. We see right through you. The world is watching. Realtor has directed the clerk to enter on the CCS and make publicly available all non-confidential document that realtor requested to be made public. Yes, because of this. Because of this. Do you think she would have made those things public had it not been for this writ? Of course not. Of course she wouldn't. She wouldn't have been reviewing the system, as she just so nonchalantly said. She wouldn't be. Moreover, respondent is under no duty to maintain the CCS. Oh, she's gaslighting the clerk of court. She's gaslighting the clerk. It's the clerk's responsibility. No way. So it's only a week ago she was ordering the clerk to take things off. She was ordering the clerk to take things off just a week ago. No way. Well, maybe 2 weeks ago now. Nor does realtor identify an absolute duty respondent violated. I think they're very clear. I think that the things that you've not done are very clear. Realtor is wrong when he suggests that the parties agreed that documents would be sealed without valid grounds to do so. Nothing of the sort happened here. Finally, it bears emphasis that this court has never issued a writ granting the type of relief Realtor seeks here. Writs are reserved to provide extraordinary relief, not to manage the CCS. Well, if you did your job and didn't tell the clerk not to put things on, and the clerk could do their job, we wouldn't be here, would we? We wouldn't be here. The Supreme Court has the power by writ of mandate and prohibition to confine the lower court within its lawful jurisdiction, blah, blah, blah. Writs of mandamus, prohibition are extraordinary remedies which are viewed with disfavour and may not be used as substitutes for appeals. So you're saying that he should just have appealed. Go on, go out, get out of here. Get out of here. This court will not issue a writ unless this realtor has a clear and unquestioned right to relief. Well, if you did your job, you'd be fine. Okay. But it's done its job. It's done its job, though, hasn't it? Done its job. Done its job. Realtor does not meet the conditions precedent. Okay. Failed to satisfy the conditions precedent or mandatory requirements. Okay, so let's just die a little here, right? Original action rules 2A, 3A4 require realtor before filing his petition to first raise the issues presented here to the trial court in a written motion. Maybe he might have done had you not fired his goddamn attorneys. You're meant to have a flaming hearing in order to at least consider firing attorneys. But no, you didn't do that either, did you? No. So don't start complaining that things haven't been followed in your court. Realtor admits he need not do so. He did not file a motion with the trial court seeking to unseal or make public any of the documents identified in his petition. The court should not entertain Realtor's position for this reason alone. There's been a lot of reasons alone here. Okay, Realtor requests that he be excused from this condition precedent due to extraordinary circumstances. Yes, indeed, extraordinary circumstances of your making. And practical impossibility. Yes, because you fired his attorneys. You fired his attorneys, Fran. What else was people meant to do? Oh, I bet she's furious. I bet she's furious that the media coalition have sent in. Oh, how timely was that? How brilliant was that? That the media coalition put that in on the 11th hour, so she didn't have chance. Like, she thought she'd done her homework. Oh, there's a funny thing on this. Hold on, if I can find it. I don't know if I can find it now. Somebody put a funny meme on Reddit, like of she thought she'd done her homework and then she had to throw it away. Okay, neither is it, blah blah blah. Rather, Realtor suggests that the Indiana rules of appellant procedure allow for excuse of an analogous condition precedent under extraordinary circumstances. Yes, because of your actions. The rules of appellant procedure do not apply to original actions and blah, blah, blah. Moreover, Realtor's claim that there is an impossibility of performance of the condition precedent is wrong. Okay. Realtor asserts that the trial court refuses to accept any filings made by attorneys Rosie and Baldwin and orders the clerk to remove anything they file. Yeah, well, that's what you said. That's what you did. You asked the clerk to remove filings. You actually did, Francis. You actually did. Yeah, but the trial court has not prohibited realtor from filing motions with the trial court via his current counsel or himself. Yeah, but he doesn't want them. Just because you've appointed them with... Do you see what she's doing? She's infuriating. She's absolutely infuriating. Infuriating. Realtor as highly competent counsel. Who are your friends from your county? Your Facebook friends? Well, at least Labrato is. Including the attorneys who filed the petition. In addition, the trial court has appointed new counsel for realtor in the trial court case, as realtor acknowledges. Yeah, because you disqualified illegally his rightful counsel. Nothing prohibits any of these lawyers from entering appearances with the trial court, including limited appearances on the issues presented in his petition, for the narrow purpose of first requesting relief from respondent. Yeah, but you'd have then sat on it for months. This has forced your hand, Francis, and that's what you're smarting about. This has forced your hand. This has done the job. This is very clever. This is very clever. What will the Supreme Court think of it? Doesn't matter, honestly, because it's done the job. It's done the job. Finally, as discussed further in the next section, realtor seeks relief arising from the respondent's actions as early as June 2023, including a trial court order dated June 28th. Blah, blah, blah. And realtor claims that he does not accept this. Oh, no way. Why have you put this in a footnote? Thinking that people, I'm just going to slip this in because people don't read footnotes. Always read footnotes, people, because all the good stuff that they don't really want you to read, but they know you've got to, they know they've got to put it in a footnote. That's what they do because you don't read small print. Okay. Realtor claims that he does not accept this appointment and he has not authorized those new attorneys to act on his behalf in any manner. This is irrelevant. Because he is not prohibited from filing a written motion with the trial court, regardless of whether he accepts the court-appointed counsel. Listen, he's sitting there in Westville being, let's say it, abused, potentially, allegedly, and you want him to sit down and write a motion that you're going to seriously take under consideration. I don't think so. I don't think so. In fact, one of the realtor's attorneys has done just that on November 2nd. Realtor's attorney, Cara Wernicke, filed a limited appearance on the purpose of requesting transcripts, in which she advised the trial court that her appearance is limited for the purpose of requesting transcripts necessary for an original action. Miss Wernicke entered this appearance in connection with another original action realtor filed. Okay, yeah. All right. Okay, great. Okay, when realtor received notice that the trial court had stricken filings from Rosie, realtor had ample opportunity to file written motions with the trial court challenging the court's decisions, but realtor never did. Realtor's compliance with Rule 2A was not an impossibility, factually, legally, or practically. The court should deny the petition for this reason alone. Another reason alone. Just do what they ask. Oh, you kind of have. At least some of it. Where's the transcript, Francis? Where's the transcript? We want the transcript. Have you got the transcript ready yet? He's dying a bit every day. Yeah. Yeah. Wonder why people go on rampages. Maybe if those at the top of some integrity. Controversial. Well, you might have a point. Original actions of mandate and prohibition must be expeditiously filed. Okay, all right. No, although no specific statutory provision prescribes the time for judicial review, such action must be brought expeditiously and without unnecessary delay. For example, this court has found that a delay of 42 days was too long to seek a writ with this court. Okay. Rather, relator boldly asserts that the application has been made expeditiously, but realtor seeks relief from actions that occurred on the following dates. June 20th, filed by Carroll County Sheriff, which was sealed for some unknown reason and is now unsealed. June 28th, trial court order. So that's the 118 documents that were zipped up and put in a Google Drive that weren't chronologically filed in the CCS, which now they are. So you've done that one as well. July 5th letter that we've read on this live stream at the beginning, which was sealed, and no, it isn't. September 18th, Frank's memorandum, which you've sealed for no good reason, because you claim that the rightful attorneys did not redact the appropriate things. But I think if you go back to your rule book, Francis, you'll realise that nothing needed to be redacted. So you can make that one public as well. But don't worry, we've all got it anyway. And the Supreme Court also have it unredacted. And it's available there for anybody who missed it. October 25th, 26th, Allen's verified notice of continuing representation, motion to disqualify, transcript and motion for continuance. So all of these things, she... where's the transcript? Where's the transcript? You've not mentioned in your filing from 2 days ago, you've not mentioned the transcript. Where is that? Where's the transcript? We want the transcript. Okay. Realtor filed this petition on October 30th. This was 42 days after Realtor filed their September 18th memorandum, the exact same delay that the Supreme Court found to be excessive. Okay. All right. Some of them are even longer. All right. Yeah, but this little shake-up has done its job, because things that were previously sealed are now unsealed, and things that were in a silly zip drive are now on the CCS, quite rightly. So you've done it anyway. You've done it anyway, and you've written this silly document. Francis, you've spent your time writing this silly document, or paying attorneys to write this silly document, even though you've done what it's required or asked you to do anyway. Who's laughing now? Very funny. Realtor's petition is expeditious only to the extent that it seeks to reinstate the October 25th, 26th, 2023 filings. However, Realtor's request for this minor relief cannot save his otherwise untimely petition. But you've done the stuff anyway, so it's done its job. This court should not issue an extraordinary writ on matters that the trial court decided months ago and that Realtor never challenged before the trial court itself. Okay. All petitions shall state facts showing clearly that the denial of the petition will result in extreme hardship, blah, blah, blah. Writs of mandamus and prohibition will not be used unless the realtor can show a clear and obvious emergency. Don't you think that this entire situation has been an emergency when failure of the Supreme Court to act will result in substantial injustice? Oh, we don't think that any injustice has been done here. No, okay, you don't think so. The world is watching. The world is watching. It's not the policy of the Supreme Court to issue these extraordinary writs against lower courts on slight occasions, blah, blah, blah. Realtor's petition claims explain below that the accompanying brief, the denial of the application will result in extreme hardship. Yeah. I wonder what she's going to say to the second writ, which is more juicy than this one. Can't wait for the 27th. Instead, Realtor argues that restricting access to the court records at issue generally harms the public, blah, blah, but stops well short of arguing that it causes the public extreme hardship. Yeah, but not putting things out there, I think the media has got a problem with. So you might want to go and read what they say. More importantly, Realtor never alleges that he would suffer extreme hardship. He's suffering extreme hardship, but in other ways. If the documents remain publicly inaccessible, blah, blah, as a party, Realtor has complete access to any court document. Oh, I don't care. Not the point. Although Realtor raises arguments about his Sixth Amendment right to counsel, these claims of harm have nothing to do with the release he seeks in this petition. Yeah, that's about the other one. But we'll wait to argue that point on the 27th. All petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. If a court decides erroneously the remedy through appeal, blah, blah. Far too frequently, writs of prohibition and mandate are sought to be used as a shortcut to an appeal on the merits, which cannot be done. Yeah, but you've done what it's asked. You've done what it's asked. So, what are you going to do now? What are you going to do now? What are you going to do now? Realtor's petition asserts that his remedy available by appeal will be inadequate, but Realtor again fails to demonstrate why appellant remedies would be inadequate, wholly or otherwise. Don't you have to wait till the trial's over to appeal stuff? Or is that just appeal on the entire case? Maybe. Smell a retirement party. Yeah. Yeah. Oh, speaking of retirement, have you heard that the beloved Judge Newman in South Carolina has recused himself from Murdoch? Have you heard that? Yeah, he has. Not for the financial crimes, but for any future issues to do with the murder case. Yeah, he has. But he's due to retire anyway. Yeah, he has, yeah. He's due to retire, but I think he realises that the attorneys are just playing silly beggars. And he can't be arsed with it, maybe. Yeah, from the murder. Not from the financial crimes trial, which is upcoming. But for the murder part of it, like the appeal to his murder. Okay, all right. For that reason, this court, an Indiana Court of Appeals, regularly entertains appeals. All right, so you think he should have appealed. All right, you've given some law. All right. Okay. Who cares? You've done it. You've done your job. Eventually. Indiana's rules of appellant procedure reinforce that the realtor may request the relief he seeks from the trial court, and if the trial court disagrees, seeks a remedy through a normal appellant process. Specifically, if any disagreement arises as to whether the clerk's record or transcript accurately discloses what occurred in the trial court or the administrative agency, any party may move the trial court or the administrative agency to resolve the disagreement. The trial court retains jurisdiction to correct or modify the clerk's record or transcript at any time before the appellant reply brief is due to be filed. After that time, the movant must request leave of the court on appeal to correct or modify the clerk's record or transcript. The trial court or administrative agency shall issue an order which shall become part of the clerk's record that either confirms the clerk's record or transcript reflects what actually occurred, or corrects the clerk's record or transcript, including a chronological case summary, if necessary, to reflect what actually occurred. Okay, whatever you say. If realtor believes that CCS is inaccurate or incomplete, it was, or that document should not be sealed, Rule 32 of the Indiana Rules of Appellant Procedure provides still another avenue for addressing any such concerns. Due to the petition's multiple procedural defects. You see, the thing is, the real reason why this was done is to alert the Supreme Court of Indiana to the nonsense that's been going on in this case. That's the real reason why this was done. All right. So this has created her some work, and then in comes the second writ, which is the more important one, or the more pertinent one to the issues. Sadie, what you do you know that JKK, who's JKK, leaked photos right after the Red Rums? You can say murders. Red Rum's a racehorse from the 1970s. He was fired for it. Those were the real pics. No one wants to talk about that. Okay. Who's JKK? All right. Okay. Even if the realtor had satisfied the conditions precedent and mandatory procedural requirements of original action, which he has not, the petition fails on the merits. At the outset, most of the relief realtor seeks now is moot. Yeah, it is moot. But it's caused you some money and some time, and the second writ is the one that you're gonna have a problem with. And it's this has made you do what you should have done months ago. I know Red Rum is murder spelt backwards, but it's also a racehorse from the 1970s. And you can say murder the right way round. There's nothing wrong with saying murder the right way round. J. Kyle Keener. I've no idea who that is. Wasn't Red Rum a movie too? I don't know. I only know Red Rum's a racehorse because he lived near here. And he won a lot of races. Jake Alkina was a photojournalist working for the Pharaoh, a local newspaper. Photos were taken 2/14/17. No, Sandy, Red Rum, as in it's murder spelt backwards, not a red drum. That's something completely different. Red Rum is from The Shining. Right, I'm going to show you the real Red Rum here. Okay. That's Red Rum. That's Southport Beach, near here. From Southport, Red Rum. And he won bunches of races. Not that I agree with horse racing, but... Okay. All right. Where were we? Respondent had issues. Respondent had issued an order directing the clerk to make available to the public on the CCS all non-confidential documents. Related requests be made public. Yeah, you did that 2 days ago because of this. Would you have done it otherwise? No, you wouldn't. But you've done it anyway, so that's good. Realtor request, remember, in any event, respondent had no absolute duty to maintain the CCS. So let's just gaslight the clerk of court more. That's the clerk's responsibility, not respondent's. Nor does respondent have an absolute duty to reinstate documents filed by attorneys after they no longer represented realtor. Well, yeah, but you've got to reinstate the attorneys that you erroneously disqualified. Maybe that's a conversation for another day, though. Respondent also has no absolute duty to provide the public with remote access to records, much less the particular form of remote access that realtor requests. What? They didn't want... No. That's not... You were the one who put the 118 documents in some silly Google Drive instead of the CCS. And now you're gaslighting the clerk of court for doing that. Most of relief realtor seeks is moot. Oh, yeah. Okay. On November 14th, 2 days ago, the trial court issued an order that resolves most of the public access issues. Okay, good. Glad you did that. Okay, so these are the things that she told them to unseal. Respondent ordered the clerk to place and make available on the CCS filings by Rosie. These filings remain stricken from the record and will not be considered because they were filed by an attorney who was not an attorney of record for realtor on the date of filing. Oh, but he was. But he was. Because you didn't disqualify him until the 31st. He was. He never withdrew. So he was. He was, though. I mean, you disqualified him without a proper hearing on the 31st. After you forced him to say he was going to withdraw, but you never accepted his withdrawal. You never accepted his withdrawal. You said you would accept his withdrawal when he... Let's listen to what she actually said, shall we? Yeah, let's listen to what she actually said. Okay, Richard Allen hearing, October 2023, Delphi. Are you ready to listen to what Francis Gull actually said?
Breaking news coming out of Delphi, Indiana. Of course, we're talking about the case against defendant Richard Allen, accused of the murders of Abby Williams and Libby.
Go away. This one. Right, you ready? Are you ready? Gull makes the perfect... She makes the perfect gaslighter. I wouldn't like to live with her, would you? Imagine being a partner. She lied from the bench. She did. Right. Are we ready? Are we ready? Are we on? Hold on. Let me know that you can hear this all right. So it's only 3 minutes of your time. Okay.
Thank you. You may be seated. We on? All right, we are on the record. State of Indiana, Allen 08 CO1 2210 MR1. Thank you for your patience, ladies and gentlemen. Thank you, Mr. McClellan, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days. They have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment. As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction. Mr. McClellan, I know that we have already scheduled a hearing in the Carroll Circuit Court October 31st at 9 a.m. I'd like to maintain that hearing.
All right. So Baldwin issued an oral motion to withdraw, which she accepted. Rosie said he would issue a written motion and she expected that in a couple of days. She never received that withdrawal for her to accept. So she cannot sit there and lie and get away with it. Surely a judge cannot sit at her bench and lie. And it doesn't matter. It does not matter if an attorney withdraws. They can be reinstated at any time. She's something else, I'm telling you. She's something else. Anyway, it's only 3.5 minutes. That's the link. That's being played from Law and Crime Network. But Rosie never withdrew. Never issued his motion. So regardless of what she thinks happened on the 19th, he never withdrew. So, no. The October 25, 26, 2023 filings by Rosie, one of which was a motion for the judge to be disqualified, she is erroneously stricken from the record because Rosie had not withdrawn. In fact, Richard Allen had already issued a letter expressing his desire for his attorneys, Rosie and Baldwin, to continue representing him. Also, Rosie, at the same time, October 25th, issued, we read it on a live stream, issued a written motion to continue his service to Richard Allen. Exactly, yeah. Richard Allen was not in chambers for that meeting. No one has heard the transcript of it or read the transcript of it. No one knows what happened. She seems to be holding that back for some godforsaken reason, even though it's been requested by numerous people. So, no. You're wrong, Francis. You're wrong. Trial court's November 14th order renders most of the issues in the petition relating to these documents moot. Good stuff. Okay, so she goes on about maintaining the CCS. It's the clerk of Carroll County Court, not the respondent. More gaslighting. To the clerk of Circuit Court shall also maintain the following records as specified under the rule. Yeah, but listen, if the judge tells the clerk to take stuff off the record, orders them to take stuff off, what are they going to do? Are they going to say no? What are they going to do? What position did she put the clerk of court in? And then she comes along and gaslights them, saying it's their job. Thank you, Tracy, for the $10. Thank you, thank you, thank you. Oh, I do try. I do try. Listen, I would be, if I was that clerk of court, I would be looking for a new job because this woman is unstable. She's unstable. Realtor concedes that the trial court clerk is to maintain the trial court records. Similarly, Realtor repeatedly refers to the person who allegedly violated the duty to provide public access to certain records as someone within the court system. Changed all of Alan's filings to confidential. Yeah, it was the clerk because you ordered them to. So who that someone was, well, was it you? Did you do it? Or did you order the clerk to do it? Whichever way, they were erroneously and against the rules made confidential when they shouldn't have been. The Franks memorandum is still confidential, although it shouldn't have been. Because whoever it was who removed those documents, including the Franks memorandum, but there are others, doesn't matter who it was under your orders. So whichever person actually physically did it, it was under your orders and your court. She's a piece of work. Trial court has broad discretion in managing its docket. Okay. Respondent has no absolute duty to maintain its docket in the manner sought by Realtor. Well, really? Really? Aren't you the judge of the law in your court? Don't you know the rules of your court? Are you the person who is making these orders? Yes. Yes. We read it on a live stream. Richard doesn't have a chance in this court. You're absolutely right. He doesn't have a chance. Nor does respondent have an absolute. I've read that. Indiana law does not require court records to be remotely accessible. We're not asking for them to be remotely accessible. We're asking them to be filed in their correct place. That's all. Not remotely accessible on a Google Drive. They shouldn't have been on a Google Drive to begin with. Respondent has ensured that the 118 documents on the zip drive have been and remain publicly available online since June 28th. But that's not the point. You know, either purposefully, because I don't believe you're a stupid person. You can't be a stupid person. You must have intelligence to be a judge, surely. They shouldn't have been on a zip drive anyway. They should have been in their appropriate place, chronologically filed. And they weren't until 2 days ago. And you only did that, put them all there chronologically because of this writ. You wouldn't have done it otherwise. Okay. Does not mean that they've been excluded from public access. No, they've been on some silly Google Drive. I'm sure that's not secure enough, but anyway. A court record may be publicly available even though... Okay. Realtor further asserts that respondent wrongly allowed the parties to agree to exclude certain records. Nothing like that happened. In trial court's June 28, 2023 order, respondent explained that the court has an undisputed legal basis for sealing certain records, including the unredacted affidavit for probable cause, listing names of juvenile witnesses. Yeah. Redacting names from of juvenile witnesses is fine. Not the point whatsoever. No one's arguing about that. No one's arguing about redacting juvenile witness names. Oh, go away. How much more of this is it? Oh, we're nearly there. It's terrible. She's gaslighting her own clerk of court. She's trying to gaslight the public here. She's lied from the bench. Oh, here we go. Realtor also seeks to unseal or restore public access to the Franks Memorandum. The Franks Memorandum contains the full and first last names of the deceased minor children who were the crime victims in this case. Oh, so that's who she wants redacting. That's it. But we all know their names. She's arguing. Let me get this straight, because I feel I'm going slightly mad here. She thinks that the Franks Memorandum should be sealed because Abby and Libby's names were not redacted. That's it. That's what she can come up with. That's what she can come up with. Names of minor children are required to be redacted from the court filings in federal courts. Indiana, in turn, excludes case records declared confidential or excluded from public access pursuant to federal law. Therefore, the Franks Memorandum is marked as confidential because counsel failed to supply a redacted version at the time of the filing. So we've known the names for 7 years. I know. So she wants that excluded from public access because they failed to redact Abby and Libby's names. That's it. Wow. 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 That's God. She's reaching so far, like she's touching the flaming moon in a minute. She's reaching that far. Finally, Realtor has not cited a single case where the Indiana Supreme Court has issued a writ of mandamus or prohibition to grant the type of relief Realtor seeks. Who cares? Okay, so this court has no more. All right. There we go. Wow. Wow. That's just insane. That is crazy. Bug Love has gifted 5 memberships. Thank you so much. You've got them. Fly on the Wall, Laurie, Robert, Unsolved Crimes Uncovered. Oh, I've been watching your channel. Unsolved Crimes Uncovered is a channel. Go and check it out. She's got a good channel. Angel RN was gifted a membership as well. Thank you, Bug Love. Thank you. Welcome, everybody. You've got a month's membership courtesy of Bug Love. So after the month, there's no tricks or anything. After the month, your membership will just kind of disappear unless you choose to rejoin. Oh, speaking of memberships, the YouTube seems to be playing silly beggars with memberships. Just reminded me to mention this. I've heard now 2 creators who've had their memberships suspended because I don't know what weird rule YouTuber initiating, but it's something about reused content. Chasing Truth, Tracy and True Crime, and Alex Erickson have both had their memberships suspended pending an appeal because of reused content or something. So I've been through my videos, and I think one of the issues is to do with YouTube Shorts. So if you make a YouTube short on TikTok and then you upload it to YouTube, I think that would count as reused content. So I've taken a load of YouTube Shorts off. So you'll notice that most of my shorts have disappeared because a lot of them are also on TikTok. I just assumed it was because of the music. So I never put music on TikToks because if I want to upload them to YouTube, I know that they will copyright claim the music. So I never put music on. But it seems potentially that it's TikToks as a whole that are, are just on there as YouTube Shorts. That would count as reused content. So I've taken those off. On Michelle Walks, my other channel, it doesn't have membership. So I've not taken those off. But I won't be uploading any more TikToks to this channel, certainly. But as I don't have memberships on Michelle Walks, I'm not really sure that it matters. Unless they start playing silly beggars with like monetization completely, then I'll have to revise it. But yeah, put all the shorts together in a long. Yeah. I think it doesn't count as reused content if you have a TikTok like in a video when the vast majority of the video is original content. I think it counts as reused content if it's just a TikTok that you upload. I don't know. That's what I'm assuming. I listened to Alex Erickson's live before I did this, and she's proper upset over it. And it's really sad when YouTube can't give you a proper answer as to what you've done wrong. At least if you know you've broken a rule, then that's one thing. But if you don't know what you've done wrong and you're trying to guess, you're trying to guess what it means, it's not right, is it? But anyway, I've not done a TikTok in a few days. I go through phases with TikTok. Sometimes I TikTok, sometimes I don't. Okay. All right, guys. There we go. Almost 3 hours, and we've got through it. So we've got to wait now to see what the Supreme Court says. Oh, Reddit's going berserk. She can't be serious with this as justifications why she removed Frank's memorandum. Yeah, I'm reading this right because Abby and Libby's last names weren't redacted. She's joking. She's not. She's not. Frank's memorandum contains the full first and last names of the deceased minor children who were crime victims in this case. Yeah, that's exactly what she's claiming, Yellow Jacket. That's exactly what she's claiming. The state's response to the Franks had their names in it too. Hey, don't remember that being sealed. Hey, good comment. Literally the most known names in any case in Indiana history, but that's why she had to pull it. Isn't it just absolutely sickening? Sickening. She's a piece of work. She's the ultimate gaslighter. She really is. The ultimate gaslighter. I can't believe what a... Anyway, let's wait and see what the Supreme Court says. The majority of that stuff has been added anyway. The Frank's motion is available in its entirety in the Supreme Court of Indiana filings. So, anyway, it's right there. It's all there. She needs to step down. She needs to step somewhere. I don't know about down. Anywhere. Step anywhere away. Step away from the courtroom. Step away from the courtroom. The world is watching. It definitely is. All right, guys. I'm going to go. Another 3 hours. Thank you all for joining me tonight. It's been a long one, but it's been an informative one, hasn't it? Let's wait and see what tomorrow brings. Thank you all for the donations. Welcome to the new members. If I missed anybody's donations, I'm really sorry. When I'm reading, I get a bit carried away. I think I've got most of them, if not all. I don't know, but welcome everybody anyway. And yeah, thanks as always to the mods. And I'm going to play out with an introduction. All right, bye guys.
Start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."